Judgment versus WWCD et al. Both sides ready?
Yes, sir.
Mr. Canigliaro, floor is yours.
Thank you, Your Honor. Good morning. May it please the court. My name is Matt Canigliaro. I am with Carlton Fields, and I'm here today on behalf of the appellant, Upper Deck. I'd like to save 4 minutes, if I could, for rebuttal. The issue before the trial court was one of prioritization in this case, and we've appealed 2 rulings the trial court made regarding prioritization. The first involving the timing of the recording of the lease and the mortgage in this case, and the second regarding the subordination provision that was contained in the lease. The more case-specific ground is the subordination provision, and I'd like to begin there. And I'll begin by stepping back a little bit and looking at sort of the lack of case law in this area. And I think there's a simple answer for why there's so little case law regarding these issues that are before the court today. And the answer is that subordination provisions are extremely common, and they generally take care of this. In this case, the trial court erred and did some straining to avoid the subordination provision. But subordination provisions are included in leases in order to address exactly these situations where a landlord has a property, leases it to a tenant, and wants to be able to borrow on the property. And here, the subordination provision said, tenant's interests in the premises shall be subordinate to any encumbrance now or hereafter placed on the premises. The point of the subordination provision was to make very clear to everyone, including McDill, the tenant, that a mortgage could be taken out later and that the tenant's interest in the premises would be subordinated to that later mortgage.
Well, let's talk about, I'm glad you started with the subordination agreement, because I think this case turns on the subordination agreement. Before the subordination agreement really applies, doesn't it have to be required by the lender? I think that's consistent with paragraph 15, and it's also consistent with mortgage between WWCD and Upper Deck, because I think it's the mortgage at the option of the lender. So don't we first need to figure out whether or not the subordination agreement was required by the lender?
Well, here, this particular mortgage didn't come about until after the lease had been executed. So,
well, I'm just looking at the language of the subordination agreement, and it says, tenant agrees to sign any documents which indicate something else other than the subordination in the lease, indicating such subordination which may be required by lenders. And then I think in the mortgage, the language says something to the effect that will be subordinate and terminable at the option of the mortgage. So I guess my starting point is, in this case, isn't the record evidence that there wasn't any subordination agreement required by Upper Deck?
in this case, I don't think the parties addressed it that way. This was done on summary judgment.
Isn't there some sort of testimony in the record from Upper Deck that they weren't familiar with any subordination agreement document that WWCD was asking McDill to sign?
I may be confusing cases, which was which. That may be the other case that was before Judge Tesharkin. In this case, I don't believe the parties.
Is that not in the record then? I know that was in the papers that I read. So are you saying that wasn't part of the summary judgment record?
That's my recollection, Your Honor, is that it wasn't part of this summary judgment proceeding.
Okay, so you don't know the answer to my question, whether or not it was required by the lender?
The answer is, of course, it was required by the lender. I'm just not uncertain how I can direct Your Honor.
Where in the record it was required by the lender?
The lender lent knowing of the lease and the lease's provisions.
That was my question, because I thought that would have been the case. Certainly constructive notice on the record, the official records, but in the mortgage, it actually said that WWCD warrants that there is no lease option exception. So I'm looking at the mortgage.
Well,
So I'm trying to reconcile that with what you're saying.
and there are some uncertainties perhaps about how the mortgage language was written.
I don't think there's uncertainty about the language, because we have to go by what the language says, and it was actually executed. So that's what the language of the mortgage says.
Well, yes, Your Honor. However, the lease is clear, though, that this is subordinated. The language in the lease is what's operative here. And
As required by the lender, which again is what I'm trying to pick up on.
well,
Okay.
that's with respect to executing documents, to the extent additional documents are necessary. And I'm trying not to combine the two cases, but if we were to combine the two cases, Judge Tesharkin in the other case was dealing with an argument that there was a breach of contract by McDill for not agreeing to execute a document that would have made clear after the fact that this was subordinate. And Judge Tesharkin said, that's not a breach. It didn't need to be executed. The language in the
But forgive me, but wasn't that required? That was something where WWCD was asking for that, correct? Not the lender. I don't want to mix the two up.
yes, Your Honor.
Okay, because it was a breach between WWCD and McDill.
Yes, Your Honor. But I point that out because ultimately the court's view was this language is plain. And in our view, this language is controlling what's in the lease. Additional documents might be helpful. In fact, in this case, it would have been helpful had there been additional documents executed. But when the lease was executed, that is the governing point in time to understand what the obligations were. And the obligations at the time the lease was executed were that this lease and the tenant's interests in the premises would be subordinate to any subsequent or future mortgages that the landlord placed on the property. That's what happened here. The landlord placed a mortgage on the property.
Well, a subsequent landlord placed, and does this lease inure to any successors and assigns of the original landlord? I see assignability by the tenant, but curiously, I don't see an assignability by the landlord.
Is the court's question whether the lease and the interest surrounding the lease? The answer is yes, as a general rule. If a property has a lease on it and the property is then sold to a new buyer, then the new buyer with notice would take with the lease.
If there's some sort of assignment, right? I mean, there's typically an assignment of leases.
I think there's often language that makes it very clear, but even in the absence of that language, I'm not aware of any law that would not allow the new purchaser to
Oh, I
step
think
into the
there's-
shoes.
That I'm saying, if I'm looking at the lease itself, I don't see an assignability from the landlord to a subsequent successor assign or whatever. I see an assignment allowed by the tenant. So I was wondering whether or not that's something we should take note of, that there's no mutual assignability.
I think the language was likely included just to make clear, because with tenants, that would not be automatic. That the tenant's rights would move to someone else. However, with respect to the landlord, they would. And so that's not been raised. This was on cross motions for summary judgment. And these are not sort of concerns that were raised either way. And so I would encourage the court to look closely at the language of the subordination provision and what the trial court's reasons were for deciding the way it decided.
But let's say the trial court here got the result right, but maybe for the wrong reason. Certainly can look at the Tipsy Coach analysis, correct?
I don't disagree with that, Your Honor, and the court can. However, the court should do that on a record that's been developed with respect to the issues that might be considered. And here, to the extent that parties haven't raised issues or challenges haven't been made, a fair.
But I think they do raise the issue that, I think it's in the brief that, there would typically be a separate subordination agreement that would have been required. And I think that's kind of consistent with the language of paragraph 15, because it talks about any documents, not anything here in the lease, but it talks about entering into a separate document. So I think that is something that they've argued in their brief.
I don't disagree there, Your Honor, but turning to the specific language that the court is focusing on, that sentence reads, tenant agrees to sign any documents indicating such subordination, which may be required by lenders. It doesn't, it's not an expansion or a contraction of the tenant's rights. It's simply a reflection of what's a fairly common notion in this sort of document, that if someone needs additional papers to be executed to reflect what's already the case, you're going to do it because that just makes the commercial transactions easier to.
Okay, but some lenders may not, they may negotiate that, hey, okay, the tenant doesn't, we want the tenant to stay there. We're not going to subordinate it, right? I mean, it's at the, I'm trying to get through the language here. The mortgage says at the option of the lender. The lease says as required by the lender, and I don't know if it was required.
But
because
not
I
to.
don't see any documents that were signed as between the lender and between McDill.
And there were none, to my knowledge.
That's what I understand as well.
However, that no such document is required for the subordination to be effective. That is a provision dealing with memorializing what the prior sentence already does. The operative language is the prior sentence. Tenant's interest in the premises shall be subordinate. It doesn't say if the lender so requests or requires, or if additional documents are signed. The two provisions often follow each other or go together, but the second provision isn't necessary. An additional document is not necessary under this language in order for the subordination provision, the first sentence, to be effective and to be operative. And that's what should be ultimately the controlling provision here. The interest in the premises shall be subordinate to any encumbrance. They make no argument that the purchase option was not an encumbrance. They say it was an encumbrance. They say it was not an interest in the premises. And as we've gone through in the briefs, there's multiple reasons why that's incorrect. First, on the contractual language here, tenant's interest in the premises, not just sort of the land or the dirt, but the interest in the premises as a whole, the land plus the property that they were renting, that those include your rights and your claims. And here within the lease, there was a contractual right to a purchase option. And so that provision would certainly, tenant's interest in the premises would include that purchase option. But the court wouldn't even need to decide that, because the much easier one, and as I read the briefs, I really don't see a response to this. The much easier way to resolve this is that once the purchase option was exercised, there can't be any dispute that the tenant's interest in the premises included that purchase option. At that point, there would have been an equitable ownership interest by virtue of having opted to make the purchase. And by virtue of this provision, and again, the first sentence is complete. It's not conditioned on additional documentation being executed. The subordination would be effective. And to go back to where I was beginning earlier, that's why we really don't have much case law on this, that these provisions are common and they're generally enforced and they're generally utilized.
Don't they typically arise where there's the existing landlord? Because what we're talking about here, it's hard for me to understand that this subordination clause reached out to a purchase money mortgage by a subsequent purchaser of the property. That seems to be quite a stretch.
We would respectfully disagree, Your Honor. I think that's what it's a right provided in the lease. And it wasn't personal to the original landlord. When the property was sold, the right moved to the successor.
By what record? I mean, other than I know the parties, it appears
There
the
has
parties.
never been a dispute that this lease applied to the parties, meaning meaning WWCD and McDill. That has never been in dispute in this litigation. And so there's, to my knowledge, not been an argument that somehow the subordination provision by itself didn't follow. That the parties operated under the lease, no one has disputed the lease was effective between these parties. And so I respect your Honor's question, but I would suggest that the answer here is that no, when WWCD bought the property, it had the rights of the landlord and the obligations, of course, of the landlord under the lease. And one of the rights it had was to mortgage the property. And in doing that, the lender would get a superior interest because the tenant's interest would be subordinated as part of the lease.
So this is a purchase money mortgage, correct?
Yes, Your Honor.
And that doesn't make a difference in your argument that it was, the mortgage was put on the property before the lease was assigned? Or is that false?
The mortgage was put on the property.
They get money, they borrow it, they pay the seller, and they take over the lease, correct?
Yes, and all that was,
So the subordination clause is the controlling factor. Whether the mortgage was put on before or after they buy the property doesn't matter.
yes, Your Honor.
And the fact that they didn't exercise the right of first refusal, that didn't extinguish the option to buy.
Yes, Your Honor.
Okay, thank you.
You're at your 4 minutes.
I don't want to be seen to have abandoned what was the lead argument in the briefing, which is this notion that challenging the trial court's ruling that this wasn't an interest in property. And I just want to just briefly reference it so the court appreciates that we stand fully on it. And the simple notion is that there are cases, and Henson being, I guess, the lead, that misinterpreted Florida law, according to what the Florida Supreme Court later made clear, in finding that a purchase option is an interest. The cases referring to purchase options as being something that themselves are subject to being prioritized, recorded, prioritized, and ultimately given superiority, all turned on the notion that these were an interest in land. And the Supreme Court clarified that there is no interest from a purchase option until the option is exercised.
So let me ask you this, isn't a tenancy an interest in property?
Yes, Your Honor.
Okay. And the tenancy here arises out of this lease, including all of its terms? We're not dealing with a separate option.
Well, it's within the lease, but just because
One
something
lease.
But just because something is within a lease, it doesn't mean it's a tenancy right. And so when you have a lease, you do have tenancy rights, you have possessory rights. And that's why you can record leases. That's why the law works the way it works in this way. But the purchase option is different. And if I could reserve my time for rebuttal, I appreciate it.
You had about 3.5 left, Mr. Familiar.
Thank you, Your Honor.
Good morning. May it please the court. My name is Evan Dix and I represent the Applee McDill Entertainment LLC. We're asking that both orders in each case be affirmed. I'd like to start on the subordination clause and address some of the questions that Judge Smith was raising. There was, as part of the summary judgment record, I think 2 important things. Number 1 was the partial final judgment from the eviction case. And Upper Deck had also filed trial transcripts from the eviction case. And part of what was at issue in that case was it was WWCD, the landlord, asking McDill sign this document. And at trial, when the representative for Upper Deck testified, She said, I've never seen this document before. So and I know the partial final judgment's at page 118 of the record in the foreclosure case. It would be a few pages in where the trial court addresses that. And one of the reasons for the trial court's ruling in that case that there was no right to eviction was because the language in the contract says that the subordination document may be required by lenders, and there was no evidence that the lender was requiring it. So we do think that's at least instructive as to, you know, what the parties were thinking and intending here in terms of the priority rights between McDill's purchase option and Upper Deck's mortgage. When you look at the language, it is limited to tenants' interest in the premises. And the premises is defined in the leases, the land and the building that's on it. It doesn't mention the purchase option. It doesn't mention claims.
Does it need to? I mean, it says plural interests. Doesn't that mean all of the tenants' interests that derive out of the lease?
It does not. Our position is that when you look at interest in the premises, I mean, that has a legal meaning attached to it. It's talking about interest in the land. And we know as a result of the argument on the first issue, which I'll get to, that the purchase option is not an interest in the land. It's an encumbrance on the property, which is legally different, and that there's significance to that. And the trial court cited the Wilcox case from this court in its summary judgment order that when you do have phrases or words like that with a definite legal meaning, that's the meaning that gets applied. And
But that's only one interest, to be fair.
well, I think that there are different.
And the language of the lease is plural, interests.
Correct. But if McDill doesn't have more than one interest in the premises, then the only interest in the premises it has would be subordinated, which is the possessory interest as a tenant. But a purchase option is not an interest in the land, as we've argued in our brief. It's a contractual right that encumbers the property. There are contracts that encumber property every day. There are encumbrances that while they encumber the property, they don't give an interest in the land. I mean, we cited the United case in our brief that talks about mortgages. They don't give an interest in land, but they encumber the property. They're a lien. It can create a cause of action in the future. Purchase options are really no different. So when you look at the language, you have to identify what are tenants' interests in the premises, and nothing beyond that is subordinated. And we cited two cases in our brief that while they're not binding, they're from other circuits and other states, I think they're instructive as to subordination clauses that were deemed sufficient to encompass a purchase option. The one from the Eighth Circuit talked about subordinating all rights under the lease, including purchase options, right of first refusals, etc. That's effectively what the lease would have had to have said here to encompass the purchase option, and it doesn't. We think that the mention of one thing means the exclusion of the others. So the mention of interest in the land excludes everything else that's not an interest in land. I do want to address the argument from the appellants about what they call the easy way out of this, which is that once McDill exercises the option, well, then it has equitable ownership and, you know, all of its rights are subordinated. That argument is wrong. Once the option's exercised, the lease ends by operation of law. The trial court cited the 12th Avenue Investments case.
Go back. You're saying that once the lease, because there's cases, I think to that effect that I read, once the tenant exercises the option, they don't have an equitable interest.
Sorry, maybe I misspoke.
Okay, yep.
So when the tenant they're a tenant and they have their purchase option, they're a tenant with a purchase option. From the moment they send notice electing to exercise the purchase option, the lease is over and they transform into the equitable owner of the property. That's in the 12th Avenue Investments case that the trial court cited at page 1417 of the record. So once McDill elected to exercise the option, the lease was over. There was no more subordination provision. And I mean, what an absurd result if McDill's got this prior encumbrance on the property, but then when they go to actually get the benefit of that encumbrance, well, now it's subordinated to this $700,000, principal mortgage. So wanted to address that argument. It's incorrect.
At some point, the owner of the property changes hands, and what, if any, effect does that have on your subordination argument?
We don't think it does. I mean, I do agree with appellant's counsel. Even if there's not a formal assignment document, I do think that by operation of law, if the ownership of the property changes, then the subsequent owner of the property would be bound by the prior owner's agreements and obligations, which includes the lease that was entered into with McDill.
Is that by operation of the recording of the lease?
No, it's by operation of the lease's existence, just by being executed. And so, appellant's counsel is right. I mean, we didn't, raise any kind of argument like that below in this case, but I do at least want to point out that it was a focal point of McDill's case in the eviction matter that WWCD should have never owned the property, because part of what was at issue in that case was the breach of a right of first refusal. Had McDill been given the information it was looking for, it would have exercised or could have exercised the right of first refusal, and we would have skipped that step from a conveyance to WWCD. It would have gone straight to McDill. So we think the plain language of the subordination clause it doesn't extend far enough to encompass the purchase option. And we think that when you look at the other provisions in the lease, it really makes sense when you look at the terms that govern the option. McDill is getting a warranty deed, which brings about covenants of good title, but it also specifically says that they're supposed to get any other corrective instruments in order to convey good and marketable title. And we cited the Bailey case. Good and marketable title also has legal meaning. It means unencumbered or free from encumbrances. So one of the points of our brief is that the trial court, or for this court, can't construe this lease in a way that McDill is supposed to get unencumbered title for a fixed sum of $350,000, while at the same time construing the lease to mean that McDill's purchase option right is subordinate to a $700,000 mortgage. And I know we make the point in our brief that it's $700,000, but in actuality, it was over $1.5 million. If you look at the summary judgment affidavit that Upper Deck filed, they said they were owed over $1.5 million as of March of 2022. And that would be an absurd result to interpret the contract that way. I do want to make sure that
emphasis should be placed on the fact that the mortgage as between WWCD and Upper Deck. WWCD represented that there was no lease, or there was no option, anything like that.
I don't think it really plays any role in the court's analysis here. I think if anything, that certainly gives Upper Deck maybe a breach of contract claim for the representation not being true. But also, Upper Deck was on constructive notice at the time the mortgage was created of this lease, because remember, McDill recorded the lease before the mortgage ever came in existence. And so that's why, I mean, there's nothing unfair about the result in this case. Upper Deck lent money using this property as collateral when it had full knowledge that there was a purchase option in McDill's favor to get good and marketable title for a fixed sum. They did it at their own peril.
I seem to remember something in the record that there was a previous opportunity presented to McDill to purchase the property, but McDill didn't think it was a serious competing offer or a serious competing party. What was that all about?
So that related to the right of first refusal claim that was at issue in the eviction case. And what was going on there is McDill was being told by the original landlord that there was some kind of offer, but they were refusing to identify who was making the offer. And so part of McDill's response was, number one, they didn't know there was a legitimate offer because they were refusing to disclose the proposed buyer's identity. But in addition to that, that was a material fact that McDill wanted to know because it mattered to McDill who their landlord might be if they decide, okay, we're not going to exercise our right of first refusal. And as you see in the partial final judgment, although he was using entities, the WWCD, the guy that's the principal of it, he's also indirectly a minority owner in McDill. So, I mean, it's kind of a disgruntled business partner type dispute where he's coming in, and we call it the secret sale in our brief because we didn't know that's who was trying to buy the property out from under McDill. I do really want to mention on the first issue that was raised that Appellant's counsel touched on. The first issue is really what is the legal significance of an unexercised purchase option. We cite cases that directly and squarely answer that question. It's a valid encumbrance on real property. And if a subsequent party, if they take rights in the property with notice of the purchase option, their rights are subject to the terms of the option. That's Hansen, that's Savoy. All of the cases that Upper Deck cite are talking about estates in land, legal or equitable estates in land. And they're being raised in the context of ownership rights. If you look at, for example, the Gaudier case or the Leon County case, those cases involve someone applying for a tax exemption. And as the basis for the exemption, the party was saying that they had an unexercised option to purchase, and that made them either the equitable or the beneficial owner of the property, so they should get the tax exemption. And the Florida Supreme Court said, no, that's not right. If you have an unexercised option, you don't have a legal or equitable estate in the land until you exercise the option. We don't think there was any reason that the Florida Supreme Court would have proceeded to analyze whether the unexercised option also created an encumbrance, because property owners are the ones who go out and apply for tax exemptions, not those that have encumbrance rights like an option. And I mean, if you take a step back and really just think about what a purchase option is, I mean, Upper Deck's argument that it's not an encumbrance is just unreasonable. I mean, an encumbrance, or excuse me, a purchase option, that is baggage on real property that can impair its marketability. If I'm going to buy a house and it has a purchase option in favor of someone else, I have to know going in that I may not be able to just buy this house and own it for as long as I want. I might have to turn around the day after I buy it and sell it to someone at a certain price. And maybe I think that's a good thing. Maybe I think that's a bad thing. But I mean, that is the very essence of what an encumbrance is. And so we don't think that there's any way the court can construe the purchase option as not creating an encumbrance. So we think our cases are on point. They answer the question, and Upper Deck's cases are an opposite. On the other appeal, no matter what the court's decision is in the foreclosure appeal, the other final judgment should be affirmed. That final judgment is largely fulfilling a ministerial act. It liquidated amounts of attorney's fees, which no one's challenged, and it set the date and the price for McDill's exercise of its option. The entitlement to the option was determined in an appeal that was resolved back in 2021. Judge Black, I know you were on the panel in that appeal. So it was just a ministerial function to tell both McDill and WWCD that you have to go specifically perform your respective obligations under the lease. That final judgment does not impact or affect or adjudicate Upper Deck's rights as they claim in that appeal. It's just ordering two parties to perform their contractual obligations. That's all the trial court had the power to do. The trial court can't vary the terms of the lease. And all the trial court did was note in a footnote, because Upper Deck had tried to file a motion to strike. They just noted in a footnote that Upper Deck and McDill are litigating in the foreclosure case. It doesn't make any decisions or adjudications about Upper Deck's rights. So no matter what the court's ruling is in the foreclosure appeal, that one should stand. I mean, as a practical matter, if the court reversed the foreclosure appeal, there'd be practical implications with respect to the exercise of the option, but nothing that would legally require the court to reverse that judgment. So, I mean, we think that the language of the contract, the case law, compels the court to affirm both orders. Happy to answer any other questions. Otherwise, I'll just end with, we'd ask you to affirm.
Thank you very much. About 3.5 or 4 months.
Thank you, Your Honor. I'll go back to something counsel said regarding upon the election, the lease expires or extinguishes. Nothing would extinguish the subordination provision in how it applies. If the option is taken, then the interest of the tenant is subordinate. And if ultimately that purchase is fulfilled, then nothing changes, that there has been a subordination agreement that has been reached and that it is operative. And nothing to the contrary was ever argued before in this case. With respect to the absurdity, I want to suggest that this is backwards. We have a lender who lent money on a mortgage, knowing that there was, counsel said full knowledge of the interest in regarding the purchase option. Well, it's full knowledge of a subordinated interest, not full knowledge that there was a superior interest. And because there's a subordination provision right there in the lease, and that language is operative.
Okay, so reconcile these two things for me. We have the language as you interpret it, the subordination language, shall, anything that's subsequent, whether or not there's a separate document or whatever. But then I have the mortgage where the language says, if there is any such existing lease, it will be subordinate to and terminable at the option of the mortgagee. At the option. So how I reconcile those two?
Well, the mortgagee, upon foreclosing and making clear that
After the fact.
yes, Your Honor, but there was the language Your Honor just referenced didn't place any obligation on the lender to take steps at the
Okay, so
at the
you're
outset.
saying At the option of the mortgagee was when they filed the foreclosure suit.
Well, at the option would be at some point during the life of these circumstances.
So they could have exercised their option at any time based on your interpretation of the lease, the subordination language.
I think what's essentially happening is the lender has the contractual right to essentially waive subordination. That's really what's going
That's what
on.
I thought, yeah.
But it's not it doesn't put a requirement on the lender in the first instance to do something in order to have subordination. And that's why ultimately the subordination provision controls. A couple of quick points regarding encumbrances and interests. The Savoy case, as we point out, didn't address this at all. There was a stray comment about what had been understood by the parties in that case that nobody litigated. It wasn't a decision. The Hansen case, we acknowledge, is adverse to us in its holding, but its language is very clear in saying that the purchase option was an interest in the property. And that's exactly what the Florida Supreme Court said is not the case. These cases that are out there suggesting that purchase options are themselves encumbrances or interests are all predicated on this notion that these are interests in the property. And counsel was talking about that, well, of course, this is an encumbrance. And we've gone through in the briefing, this is sort of the definition of encumbrance and what it is. And the purchase option standing alone is not an encumbrance, unexercised. When it's exercised, that changes everything. But here, the material fact is that the purchase option had not been exercised when the mortgage was given and the lender came in. And so the priority must be that the lender is superior to the purchase option. And that's, as a matter of law, under larger principles, and that's why I began with this, more narrowly in this case, as a matter of contract, because of what McDill agreed to in this lease. So I'll close by saying that with respect to the main appeal out of the foreclosure case, we ask that the court reverse the summary judgment and send the case back for further proceedings. And just to clarify, regarding the entire point of the second appeal was solely to be careful. There is language in that order, that judgment, that quotes from the earlier appeal, and we did not want to take any chance that there would be an argument later that because somehow that stood unchallenged, that it somehow bound Upper Deck in any way. And when we've heard counsel in the briefs and again today basically acknowledge Upper Deck's rights were not resolved in that case. And for that reason, frankly, the judgment just shouldn't include language about this, but we ask that the court reverse. Thank you.
Thank you very much. We'll be in a very brief recess while we switch the panel around.
All rise.